All right. Good evening, everyone. Can you all hear me clearly now?
Good evening, sir. Yes, we can hear you, sir.
Oh, thank you. I want to welcome everybody to today's webinar on navigating intellectual property in the digital age, and I'm so glad to see Miss Wood on the call. Thank you so much for coming. And speaker also. Thank you so much for coming. So this is a special webinar that is organized by AfriVatech. All right. Okay. Please, can you all hear me now?
Yes, we can hear you.
Please. All right.
We can hear you.
Because we observe a lapses among university students as regards intellectual property, and that is why we have bring these webinars together, and we have experts in the house that will be taking us on the journey. Thank you so much. Over to you, Dede.
Hello, everyone. Good evening. Evening, where I am. Let me turn on my video. Can everyone hear me?
Yes.
Okay.
Yes.
Good evening, everyone. My name is Dideoluwa Alaimola, and I am the IP manager of AfriVatech. I welcome everyone to today's webinar. Like Adewale has mentioned, it's because we have noticed that in the IP knowledge of university students and many Nigerians at large. So we are hoping that this webinar is a way that can inform everyone. And yes, please, I want everyone to listen. And if you have any questions, please don't hesitate to just raise your hands and ask. So I'll be welcoming Miss Woods to the call now. I'll be reading a citation in a minute so we can understand who is speaking to us. Okay. So, Michelle Woods, she is the director of the Copyright Division of the World Intellectual Property Organization. Ms. Woods she has over 30 years of experience in copyright law and joined the World Intellectual Property Organization in 2012. She leads the division's assistance to member states with updating national copyright and related rights laws, as well as joining and implementing World Intellectual Property Organization copyright and related rights treaties. She also serves as the secretary to the World Intellectual Property Standing Committee on Copyright and Related Rights, overseeing the work of the Secretariat for the committee. She was the secretary for the diplomatic conferences that adopted the text of the Beijing Treaty on Audiovisual performances in June 2012, and the Marrakesh Treaty to facilitate access to published works for persons who are born blind, visually impaired, or otherwise print disabled in June 2013. Before joining the World Intellectual Property Organization, Ms. Woods was the Assistant Registrar for Policy and International Affairs in the United States Copyright Office. Prior to joining the United States Copyright Office, Ms. Woods practiced intellectual property law with a focus on copyright as counsel in the Intellectual Property and Technology Group at the law firm Arnold and Porter LLP in Washington. Let's welcome Ms. Woods as she begins her session with us. You cannot react with a clap. Thank you, Ms. Woods. You have the floor, ma.
Great. Thank you very much. So I'm going to try to share my screen now. If it doesn't work, we'll figure something else out, but I think this should work. Oop. Okay. see. So does that look all right?
Yes, it does, ma'am.
Great. Okay. Thank you. So if there's any problem, just let me know. So thank you very much for inviting me to join you here today and to share a little bit
Recording
about
in
what we
progress.
do at the World Intellectual Property Organization, WIPO or WIPO. And I am very much coming to you from the copyright perspective. So I'm glad to see you have a colleague from another area who will be speaking to you. And for example, in the future, you may want to talk to someone who does patents or trademarks or some of our other work. But my focus today, in the limited time we have, will be on copyright law in the digital age and navigating intellectual property issues there. So I plan to tell you a little bit about what we do, what some of the current issues are that we're working with, and then go on to have a discussion, including answering any questions that you might have. Just going to flag that I do have to actually leave at 5 because I have to go to the airport to fly back to Geneva. I'm actually in London. I was here for a work trip. So apologies if we have a little less time than we would have liked, but I think we can still talk about a lot. And happy to, of course, continue later by, WhatsApp or LinkedIn or whatever works for you. So, in terms of what we do at WIPO, many of you may know this, but I'll just briefly run over it. We're an international organization. We are actually a United Nations specialized agency. The agency didn't start as part of the UN, but in the 1970s became part of the UN. We're headquartered in Geneva, Switzerland. We have a few small regional offices around the world, but the vast majority of our work is done in Geneva. The organization runs major international registration systems for patents and trademarks, including designs. These are not what I'm going to talk about because I don't work in that area, but it is important to have a sense of that, in part because that makes the organization a little different from other UN agencies. We offer fee-based services, and the vast majority of our funding comes from that. This leads to us being run perhaps a little more like a business than some other UN organizations might be, just because they really are coming from a different perspective. So let's see. We have 193 member states. That represents about 97% of the countries in the world. And our overall mandate is to promote the protection and use of intellectual property worldwide. The work tends to be divided in different areas, partly substantive, patents, trademarks, copyrights, but also there are a lot of cross-cutting initiatives. For example, we have a lot of focus on development, on countries that are in development and the needs that they have, which might be somewhat different from what the developed countries would focus on in terms of intellectual property. So that work goes across the organization. And there are many other areas that also cross the organization, including meeting global challenges, the work of our academy. So as I said, I will focus on copyright because that's the area I work in, but there is much more to the organization. We have a medium-term strategic plan that drives a lot of our work, and our Director General was new when this plan was adopted. He came in 2022, and he was our first Director General from outside the organization, although he actually had been the chair of our copyright committee, so he was pretty familiar with WIPO. His name is Darren Tang. He is from Singapore, and he was very instrumental in coming up with a new vision statement that we are seeking a world where innovation and creativity from anywhere is supported by intellectual property for the good of everyone. So a lot of the focus for the organization now is on helping individual innovators and creators, small businesses, startups, women creators, youth. And the way that translates in my area, copyright, is that we're working very hard with creative industries, including in many countries around the world, to help them start up, to help that be an important part of the local economy. And our member states very much want that support and do want creative industries to be thriving and to contribute to the national economy. Sometimes it can be a good entry point for countries while building infrastructure to focus on creative industries. You can't completely generalize, but some of those industries cost less to start up than, say, those that would lead to a very active patent industry. So the mission of the organization is also inspired by the United Nations strategic sustainable development goals. And as working on technical work that we do, because in many ways we're a technical agency, we do have this background and vision in mind. I'm showing here a picture of the WIPO assemblies. The assembly meet once per year, and all the member states come together. This is where they make decisions about the future path of the organization and where we will get options. For example, I'm the secretary of the copyright committee. We'll get on from the assembly on what the copyright committee focused on, and this is true across the organization. And so it's a very important cycle to hear from member states in this context. We also hear from member states all the time outside of the formal context, but this is one major way we interact. So I'm talking copyright. I'm sure most of you are familiar with this, but just to go over the basics, copyright literally comes from the concept of the right to copy. And in the common law legal tradition, this basically evolved in the United Kingdom, in England, with what's called the Statute of Anne, and was really focused on making copies of works through printing and distributing them. So those were the first rights that were given. And in fact, they weren't really given usually to authors unless the authors also happened to be the printers. So this is where really the origin of monetizing copyright, monetizing the right to distribute and to reproduce and distribute original creative works. At the time, it was mainly talking about books, but this is expanded to cover many, many other categories, including music, including film, including software, including databases, so architectural drawings. So it can include types of works that you might not necessarily think would be covered by copyright. There is also a parallel concept that evolved in the civil law countries, but focused more on the individual author as the creator. And so that's called author's right. At WIPO, we do use the term copyright, but it is meant to subsume both sets of rights. And more and more, given global copyright treaties and international trade, the elements of the two legal systems in terms of copyright have really become more harmonized across countries. Finally, there is something called related rights to copyright, where the rights aren't for the original creator or a person given the rights of the individual creator through some mechanism like contract. These would be people or organizations, depending on the law. In some countries, it can only be a person, in some, it could be an organization that act as intermediaries between authors and creators and their works, they can add value to the work, help distribute the work. So typical kinds of works covered by related rights might be sound recordings, so digital files that are streamed on Spotify, or originally those were records, physical records, but now digital files are covered. And important to our theme today, really, digital versions of all kinds of works are also covered by copyright. So turning a little bit to the work we're doing at WIPO, I'm not going to go through all this in detail, you'll be glad to hear, but I wanted to give you a sense of the many kinds of issues that we handle in the copyright area, including the Standing Committee on Copyright, which focuses on new developments and possible new international treaties, although the work doesn't have to lead to treaties. It was originally set up with the idea that there might be new ways of harmonizing law, copyright law, across countries, but there's been a strong movement of some member states to say that harmonization shouldn't just be through binding international instruments, but also through other mechanisms, what can be called soft law, or even just general discussion and sharing experiences. We also do a lot of technical assistance where we'll work directly with member states on, for example, updating their national copyright laws or incorporating our international copyright treaties into the local law. We also have an area that works with some of the services that are important to get creators paid. These tend to be called collective management organizations. These organizations will collect royalties, say, for all of the tiny units of payment that may go to creators, and then will package those and redistribute them to the creators. So when you're hearing about complaints from artists, for example, about very small amounts of remuneration, they may be getting these through these collective management organizations. So our area of the copyright work at WIPO is this committee, copyright committee I mentioned, helping to administer the copyright treaties and helping member states join them, and then also helping member states work on their national legislation. And even countries that had very strong copyright laws, 40 years ago, 50 years ago, they basically all needed to update the laws for the digital era. And that's something we've been working on continuously. We also do a lot of studies, lectures on emerging copyright topics, and provide a space where there can be international discussions on those topics. For example, artificial intelligence is a huge area of work for us right now. There may or may not end up being an international treaty, but as I'll mention a little later, AI, and particularly generative AI, has a very large impact on copyright law and on the operation of the creative industries and the ultimate ability of creators to earn a living through their creations, through their creative works. So I mentioned before that we provide assistance in terms of implementing treaties, and this is often tied to our assistance to member states directly. And so in terms of the treaties, I'll show you in a minute, there are quite a few of them, but we're mostly working on the ones to update the law for the digital era. When we're helping member states with their laws, this is based on requests from the member states, and we can be doing everything from drafting a whole new law to looking at a particular provision and helping maybe to update it to comply with the latest treaties. We have a lot of demand for this kind of work, and so try and keep up, but many member states are trying to address these issues kind of at the same time. So I mentioned the copyright law treaties, and this graphic shows the major treaties. I won't go through all of them, but we'll just point out that the principles, the basic principles of copyright were updated for the modern era in the Berne Convention, which was first adopted in 1886. There have been different versions since, but the last one is from 1979. So that convention really sets out the core principles of copyright. The Rome Convention, adopted in 1961, sets out core principles of those related rights, for the rights not for the creators, but others who are very much involved in the copyrighted works. And so a lot of what we've been doing since is really working to update those treaties or the topics they cover in the digital age. The treaties basically talk about rights, copyright, but what is included in that? What does the copyright owner, the author or the creator, or the person given the rights by transfer from that person, which is allowed, what what rights does that person have? So that can be copying at its most basic, reproducing, including digital copies, can be distributing, whether that's physical book sales, record sales, um, sending around, it used to be sending around reels of film. Now all of these things are available digitally, and some are only done digitally. And there have been some newer treaties, including these internet treaties, that update the rights and make it clear that digital creation of works, storage of works, distribution of works, that all of that is also covered by these rights of the authors and creators, and so that they should still be able to make a living and to distribute and to what it's called exploit their works, to get paid for their works. And there have been a lot of clarifications, basically all going in the direction of saying, yes, it is, these rights do extend to activity on the internet, to the digital age. And the most recent treaty we have, the Marrakesh Treaty, is a little bit different, but still heavily bound up in digital technology. This is a treaty to benefit persons who are blind and visually impaired, and to allow exceptions to copyright rights so that works, mainly books, but other kinds of printed works as well, can be made accessible in formats that can be read by the blind, visually impaired, or otherwise print disabled. And there is no requirement to get permission from the original author. So the copyright system does have these exceptions and limitations that offer kind of a safety valve for usage of works without payment, and sometimes without permission. That varies. But or sometimes also payment may be through what's called a compulsory license, where the amount is established by a board or the government or some entity. And so the creator doesn't get to negotiate that. It's not in the marketplace, but there could be some payment. In the case of the Marrakesh Treaty, there is an optional provision that member states could provide, for example, for payment, but most member states have not done that as yet. So sometimes these exceptions are more broadly to facilitate education, for example. And in the case of the Marrakesh Treaty, the proponents, mainly blind organizations, the World Blind Union, national members, were strongly advocating that they needed a treaty in order to bring attention to this need, particularly to facilitate educational uses of works for persons who are blind and visually impaired, and that they were requesting what's kind of a top-down model, that the treaty be adopted and then national law provisions be adopted to implement it. So we've been working a lot on that. That's a bit of a sort of different kind of treaty, but one that many member states are really committed to. And it may be that this will be more the future trend of our work. We'll have to see. So if we look at the number of members of the treaties, of our member states, 193 of them, almost all of them are members of the Berne Convention. And then after that, in fact, the most member states are members of this Marrakesh Treaty to provide this copyright exception for a target audience of group of beneficiaries. 123 member states are covered by the Marrakesh Treaty obligations. Now, you see the number 97, and then you see 123. The European Union joined as a bloc, and so they cover 26 member states while counting as one treaty member. So that is something that if the organization that wants to join WIPO does have a formal internal charter or ruling saying that they represent the member states, and they would be the ones actually voting or actually speaking in the committee, then they can be the member rather than the member states. So that may be something we see more of. I know there have been discussions about whether the African Union would do that. At least in copyright, they haven't thus far, but certainly could be something that happens in any region really in the future. So our committee meets about twice a year. We're supposed to look at emerging issues of copyright and work on new harmonizations of them, or at least awareness of them among member states. We have been in a bit of a stalemate for a long time. The committee hasn't been able to complete work on many issues. So the things you see at the top of the agenda, protection of broadcasting organizations, limitations and exceptions to copyright, like the one I just mentioned for the Marrakesh Treaty, these have been on the agenda for a very long time. Broadcasting over 25 years, limitations and exceptions over since 2008. There has been one treaty out of that area, the Marrakesh Treaty, but there are a lot of other topics there. Then we have other matters proposed by member states to be added to the standing agenda. And the committee hasn't agreed to move those matters to the standing agenda yet, because many of the members say we have to finish work on the topics that have been on the agenda longest before bringing on new topics. But there are some very important topics here, and most notably relevant for our discussion, analysis of copyright related to the digital environment. And under that, we do have artificial intelligence, among other topics. Another big one there is music streaming. So in practice, the committee has been spending some time on these other matters, and most of the time on the broadcasting and the limitations and exceptions. And then, unfortunately, a lot of time discussing how the agenda should be arranged, which unfortunately takes away from the substantive topics, but does reflect the strength of the interest of member states. So in terms of the topics before the committee, one is a proposed treaty to update the rights of broadcasting organizations for the digital era. Broadcasting organizations have those related rights that I mentioned. So basically because they distribute, disseminate programming, and often help to package it or fund it, etc. So this has actually been on the agenda of the committee since the committee started meeting about 30 years ago. And the whole situation has evolved in terms of the technologies, structure of broadcasting organizations, structure of the broadcasting industry, distribution over the internet, which didn't even exist at the time this was first proposed. So the topic's been on the agenda for a really long time, but at the same time, it has evolved. And that's part of the reason it has been really difficult for member states to reach final agreement on a text and to adopt a new treaty, because the technology keeps evolving so quickly. But the idea would be to focus on digital piracy of broadcasting signals, which now, of course, can be distributed around the world with very little notice, almost immediately. And one of the big areas where broadcasting organizations say they need this support, and member states say they need support to have legal remedies that can be available immediately, is for large sporting events like the Olympics, like the World Cup, these kinds of major international sporting events where there is lots and lots of piracy. And yet the way the events are funded is by selling the broadcasting rights. And so if the broadcasting rights aren't worth enough, it may be that the system for funding these international competitions may not work anymore. There are many, many other examples of the kinds of programming that gets pirated, but this is an ongoing issue, and there's certainly commitment among member states that a solution is needed. But the technical aspects of how that should work and how that fits with copyright law and the digital version of copyright law has been very complicated to sort out. Okay, it has stopped working. Let me see. Right. Okay, there we go. So I'm not going to spend a lot of time there. Limitations and exceptions. I mentioned this before, and that there are other areas besides the beneficiaries, the blind and visually impaired. Libraries, archives, and museums have relied for, so cultural heritage institutions have relied on exceptions to make copies of works and preserve them. Sometimes in order to have them in case of some kind of disaster. There are different reasons, but also educational and research institutions and um, educational entities from across the board do ask for the ability to use copyrighted works, not for, generally speaking, not for commercial purposes, but to allow them to be used broadly in education that can reach everyone. At the same time, creators will say, that education is a market for them, and so that they should not be completely cut off from being able to sell these works to governments, to educational organizations. So this has been an ongoing debate for a very long time, and is one that continues to be discussed in the committee. While the committee is discussing the broader principles and whether it's possible, for example, to have an international treaty on, say, copyright as it relates to libraries and exceptions for libraries, at the same time, we do work on practical projects that can help member states, like toolkits with legal provisions that member states could consider adopting in their laws to have various types of education exceptions to copyright law. So there is work that goes on the side to help member states while this broader discussion of how, for example, these exceptions could be updated for the digital era are carried on. And copyright law is territorial. It's really based on national law, national status. However, in the digital era, when works can be easily transmitted across borders, many of these entities are saying they need, even if they have existing exceptions under national law, they need something broader and they need it to work across borders. So these are some of the questions the committee is struggling with as they look at these topics. We're working on under a new work program that was adopted in March 2023 for the committee. It was actually originally proposed by the African group. In all the UN organizations and also in ours, there are groups of member states that act or speak under one coordinator, mostly organized regionally, not all. There's also one of the developing countries that in our system is called Group B because they meet in Room B, but is basically made up of developed countries, but not all of them. Some countries may choose to stay in a regional grouping. So there are different groups that will make proposals and work with each other to move them forward. And a version was adopted that includes a lot of issues, and most of these touch on digital era issues. So limitations and exceptions for teaching, for using digital and online tools, for libraries, archives, and museums, for persons with disabilities other than visual impairment, for example, maybe hearing impairment. Not every disability has a link to copyright or a need for copyrighted works, but certainly if someone cannot hear a film or a television program, that could be something where a copyright exception for captioning, for example, might be useful. So then there's a lot of discussion about text and data mining for research. So being able to do research on large quantities of copyrighted works at the same time. This has become very interesting in the AI discussion because sometimes these big databases are being used also to train large language models in the AI and to help develop generative AI tools. But there are a lot of questions about, if that material was really gathered for other research purposes, is that an appropriate use? And also, what should be the compensation, if any, to the authors and creators if all those works have copyright and are used to train AI models? This is something being worked out in the courts right now, and in different member states, but we're definitely seeing it in the committee. We've also got discussions on open science, on all kinds of other cross-border issues. So we also have this topic I mentioned before, copyright in the digital environment. It started out being more about, for example, music streaming compensation. How much of the value of the compensation for stream of music on the many, many different platforms available nationally, regionally, internationally, gets back to the creator or the author. And there's a lot of concern in many, many areas that the authors and creators may not be getting enough of a share of the remuneration. And so that was the discussion here. But now AI has been put under this area. And so a lot of our discussion has really turned to artificial intelligence, the impact of that on the creative industries. And so we had what's called an information session, where the goal was not to negotiate a treaty or anything, but simply to bring the member states important information about a topic in the copyright area. And we focused on the rights of creators, how creators are using AI, how creators are being harmed by AI, what are some of the emerging solutions to allow creators to be compensated and to continue their livelihoods at the same time that works are being generated by AI. And so this is an area the committee definitely wants us to do more work in, including some of these questions about text and data mining exceptions, whether those should be allowed to apply to use of works for generative AI training tools. What are the licensing models out there? Basic copyright questions have been raised as well. If an AI tool creates a work, a creative work that looks like a painting, sounds like music, whatever, is that actually a copyrightable work? So should that be controlled under copyright? Should there be some other registration system? If not, is there infringement if the system that created the work, even if no human author was involved, was fed on this web scraping and training data that included copyrighted works? Are those whose works have gone into those models entitled to some kind of compensation when new works are created? And there can be different questions if the created works have some clear resemblance to the previous works or if they don't. So lots of discussions both on what we call the input side, using copyrighted works for training AI models, and the output side, when an AI tool creates a work, as to how copyright should apply. Should the copyright system even be part of regulating this? Should there be some other form of regulation? Can there be licensing? There are some licensing deals going on, but will that actually address all the questions, or would there need to be in parallel some kind of local, national, regional, international guidelines, or even binding treaties eventually? Usually, as is the case with all new technological developments, the law takes a long time, follows behind the markets. But here, there is a concern that if it takes too long, the technology will evolve again, and the legal discussion will become irrelevant. So I'm not going to get into all this just because of lack of time, but one interesting question that's come up about if human authorship is needed to create a copyrighted work, which many legal systems would say it is needed, some input, some human creativity is needed. Is it enough if a human designed the prompts that are used in an AI tool to create the work? And right now, for example, in the US, the answer is no. But in China, there's at least one court that has found that the answer is yes, where there were, I think it was 54, either 54 or 56 prompts, very detailed and specific, that were used to create a work. The court found that that itself was the human creativity element needed to find that the work was actually a copyrighted work. So we will see there are a lot of pending litigation matters out all over the world, how these questions evolve. But in the meantime, the marketplace is rushing forward. So we are looking at a whole range of AI issues, and I'm mentioning what we're doing in the Copyright Committee, but even at WIPO, we have a lot of other areas where we're working on AI. The United Nations we're weighing in on that because, of course, intellectual property is not the only area affected by artificial intelligence. Here I've listed some of the other issues that come up in terms of transparency and accountability, and many other areas where IP could be related to it or not at all, but where there's still real concerns. So this is just a picture of some of the presentations that were made with artists during our information session. There's a lot of really interesting work going on in this area, and this is one of the primary areas where digital technology is having a huge impact on intellectual property, and we're probably only at the start of that in the AI field. So we've been asked to have another one of these information sessions at our next meeting, which will be in April. And member states have said they want to talk more. So they want to talk about what solutions they have, what problems they have. And so that's how we're setting it up. Probably it will not be as exciting as watching presentations from artists using AI, but the member states want to move to the next step about, okay, now, what should we do about this? And certainly that's a really important conversation that we're very happy to support. So I will stop there, and I'd be happy to take any questions, comments, or to hear any of your thoughts on any of these topics. Thank you.
Thank you, Ms. Woods. That was an interesting session. I was intrigued hearing all of the ways that the World Intellectual Property Organization has been implementing to just promote artificial intelligence and copyright. Thank you for that educative session. I was very intrigued. So does anyone have questions? Questions from anyone in the audience? If you have a question, you can just either type it in the chat box or raise your hand. No questions? Okay, so I'm going to call someone to just tell me whatever they learned from this session. I think I heard someone speaking. Adewale, did you want to say something?
All right. A question. Yes, I have a question. Thank you so much for the wonderful presentation. So I have a question as regards protection. So the question is, if AI is, I'm trying to, I want to frame it very well. Now, the question is, an AI system contribute to the current of
I'm
innovation
afraid I'm really having trouble hearing. It's cutting out.
as a parent application. Can you hear me?
It's breaking up a lot.
Okay. Maybe I send the question, Charles, so that.
Sure, you could put it in the chat
Oh,
box. That would
sorry.
be great.
All right. I'm coming.
I just saw Adewale's question. It said if an AI system, Miss Woods, can you hear me?
Yes.
Okay, it said if an AI system contributes to the creation of a novel invention, can the AI be named as an inventor in patent applications? That's his question.
Okay, great. And that is a question that has been raised in a lot of, because of the territorial nature of IP and a lot of national systems thus far. The vast majority of national systems have said no, that you also need a human to have a patent, to receive the patent. However, there is an organized campaign by an inventor to challenge this finding in different legal systems. And so there's starting to be some decisions that perhaps at least are considering the idea. But as of now, it would be very difficult to get an AI tool to be granted a patent. But the idea is definitely out there. The question is out there. And as with a number of questions on AI, we'll see how the case law develops. Thus far, most of the cases have been negative. No, the AI tool in itself cannot be given a patent.
All right, thank you, Ma. Adewale, did you hear that? Okay, I believe Adewale must have heard that. Abiola Salawo, I saw you raising your hand now. Do you want to ask a question? Can
Oh
unmute that.
no, it was similar to what Wale asked, so I think I'll just pass.
Okay, so I have a question. I was just thinking back to what you said, Miss Woods, and you mentioned that in China they have 53 prompts or something along those lines that can be used for AI systems. So I just want to know whether those are the specific prompts that can be used for every generative AI, or can people that want to use generative AI, can they expand beyond those prompts in China, since it's just China that has approved the use of prompts?
Yeah. So, two things there. First, this is one court and one decision in China. there are also some other decisions in China that seem to follow a broader principle that you do have to have a human author in order to have an copyright in a work, and that using an AI tool is not sufficient to allow a copyright to be granted. So there may be a clarification eventually in the Chinese law, but this specific decision was talking about what kind of basically prompt or instruction is given to an AI tool. So in that case, the AI tool was creating a painting or a drawing of a woman, and so the request was to create a woman with very specific characteristics. And each time we use, for example, Chat GPT or another AI tool, if we're asking a question, that is a prompt. So the prompt is just basically the instructions to the tool. And there, the court was saying that, yeah, this specific set was detailed enough and showed enough creativity in what the AI tool was being asked to do that it could be considered that the result really was the result of human creativity, so that you could look at the nature of these prompts. And one thing the court said was that they tried and you could reach the same result by putting in the same prompts. So, if you have something that's so generic, draw me the picture of a woman, you could get thousands, millions of different outputs from that. But here, where it was very, very specific, that was viewed as demonstrating creativity and originality from the author. And just to make it more complicated, different countries have different levels of creativity or originality that they might require in order to have a copyright granted. So just because a Chinese court finds that adequate doesn't mean that a Nigerian court or a Senegalese court or a Swiss court would find the same thing. So,
Thank you.
but there can be any number of prompts, any question you can think of basically to ask the tool is in itself a prompt.
Okay.
So,
Thank you.
okay.
Thank
You're
you very much.
welcome.
Any more questions? Okay, I think that brings us to the end of our session. Thank you for speaking to us this evening, Miss Woods. I had an interesting session. Yeah. Okay, so you can all react with a clap or any emoji of our choice. Appreciating Miss Woods. Thank you.
Thank you very much. Very nice to talk to you all.
Thank you, Ma. Okay. So Abiola Salawu, you have the floor now.
Okay, good evening. Thank you very much, Jide Oluwa. Can you confirm that you can hear me?
I can hear you.
Okay, thank you. Good evening, good day, everyone. Trust that we are having an informative time at the webinar so far. I've learned so much from the first session. There was so much insight, and I believe that we are all learning too. And I look forward to the other session at the webinar. So, quickly, we know that this webinar is organized by the legal and IP department of AfriVatech. So I would be sharing some information about the organization, AfriVatech. So rebranded in 2024 from CTech, AfriVatech has developed a focus on intellectual property, research, AI ethics, and education. The team is diverse with over 60% of its members being women, reflecting a strong commitment to gender equality and sustainability. The company's tagline, Innovative Minds Building Better Networks, aligns with its vision of harnessing technology to foster growth and solve problems across the continent. AfriVatech operates with a strong belief in Africa's potential, leveraging data-driven solutions to basically drive innovations. Our goal is to drive innovation by leveraging by leveraging data-driven solutions. AfriVatech is not only pushing the boundaries of technological innovation, but is also creating a space for meaningful dialogue about the future of Africa's economy by focusing on sustainability, technology, and intellectual property rights, which is why we're having this webinar, which is focused on um, intellectual property, basically. So this webinar is titled Navigating Intellectual Property in the Digital Age. So this is one of our major focuses that we're working on in AfriVatech. So yeah, basically that's a short introduction to AfriVatech, and I believe that that has given us some insight into the organization and what we do as an organization. So if you need further information, you can just check out our LinkedIn account or our social media handles so you can know more about AfriVatech and the work we're doing. So yeah, thank you for joining everyone. I hope that whatever platform you're joining from, Zoom or YouTube, you enjoy the rest of the webinar. I believe that some people are watching via YouTube. And basically, I hope that you enjoyed the rest of the webinar. We've learned so much, and there is still so much more to learn from the coming sessions. So yeah, thank you very much, everyone. Let's enjoy the rest of the webinar.
Okay, thank you, Abiola. So if, like Abiola has said, if you have any questions or clarification about what AfriVatech does, you can always reach out to us via our social media pages. So yes, that's it. I'll be introducing the next speaker now. We have Miss Olaronke Famuyiwa on the call already, and she'll be taking the second half of the session on navigating IP, intellectual property, in the digital age. So Miss Olaronke Famuyiwa is the program manager of the World Intellectual Property Organization, Nigeria, and we are glad to have her here. So let's all welcome her on board. Ms. Famuyiwa, you have the floor, ma'am. Ms. Famuyiwa, you have the floor, ma'am. Hello, ma. I think you're trying to speak, but we can't hear you.
I think our speaker is muted.
Okay, let me see. It's not muted on my end, though. No. think it's connection issue. Disconnected.
Hello everyone. So sorry about that. Am I audible now?
Yes, I can hear
Okay.
you.
Yeah.
Okay, I don't know what is wrong with my computer. Like my office computer isn't. So I'm joined from my phone. So it means I don't have my presentation on my phone. So I may not be able to share, but I'll keep trying to join back with my laptop, and hopefully I can share my presentation. Okay. I was just saying, hello?
Yes, you can go on, ma.
Okay, so I was just saying thank you very much, Delu, for the introduction. And it's good to be with you guys. Like she said, my name is Olarinke Famuyiwa, and I work for the WIPO Nigeria office as a program officer. And I'll be taking us through mainly, like my senior colleague had said before she just left the meeting, she had really taken us through what the office organization is doing with respect to copyright in the digital age. But what I would just like to do is to make my presentation in the applicable to what we do in our daily lives. Before I start, I would sort of like to get a sense of where everyone is for. I think from what Abiola has sent to me, she said this is a webinar organized by for university students. So if I could get maybe like a short intro, it doesn't have to be long, or maybe if Abiola or any of the organizers can give me a rundown of the kind of audience that we have, university students of which school, which faculty, which courses are they studying, and maybe that would sort of help me understand what their interest in IP is and maybe help with the kind of discussion we have also. So maybe just like a minute or two, someone could just help me with that.
Okay, thank you very much, Ma. It's great to have you here. So, I'll just give like a mini introduction. So mainly, our main audience are mainly tertiary institution students, so that's university students, with a focus on University of Ibadan students, even though they are students from other universities, but mainly university students. And so the aim is to enhance intellectual property information amongst university students in tertiary institutions. So the webinar in the University of Ibadan as a focus, the webinar is supported by the Law Student Society and the Technology and Engineering Students Association. So we would have a number of law students and a number of students of the Faculty of Technology and Engineering as members of the webinar, though there are also other members besides those in these faculties.
Okay, I think that sort of helped to know that there are some law students and some innovators in the house. So yes, thank you everyone once again. Really sorry for my presentation. I'm still trying to sort of boot my laptop. It's crazy. It happened just when I was about to start my own presentation. But first off, like we always do at WIPO, we always start with an introduction to the organization and what we do, and then we'll start the lecture. As Michelle had said already, WIPO is a UN specialized agency. We administer the intellectual property globally. And like she also said, WIPO has 193 member states, Nigeria inclusive. So Nigeria is also a member of WIPO. And at WIPO Nigeria, bringing it home to, I believe most of us are Nigerian students. So there's a WIPO Nigeria office, and we are located within the United Nations House in Abuja. WIPO is headquartered in Geneva, but we have about 7 external offices. And thankfully, luckily, Nigeria happens to be one of the countries that hosts one of the 7 external offices that we have at WIPO. The WIPO Nigeria office was established in January 2020, and it's been 4 years plus since we started running the organization. We work mainly with the IP institutions in Nigeria. We also work with SMEs, we work with innovators, and we work with investors. We work also very closely with students and UCOP members to disseminate intellectual property. So our main focus is to ensure that we are creating awareness and we're building capacity on intellectual property. And like Michelle has also said, our vision at headquarters also include ensuring that innovation and creativity around the world is supported by intellectual property. And this is important because it is almost impossible for, like, I say something, I said the world revolves around IP. Your creativity, your innovation, inventions that makes the world go round, technologies, even in the digital age as we're talking right now, that makes the world functions better, are all supported and protected by intellectual property. And that is what we do at WIPO and what we focus on. So I'm going to go further now to start talking about IP. I will take it slowly and I will try as much as possible to make it applicable to our course of study, that is lawyers and some innovators. So what is intellectual property? As simple as it is, intellectual property. Like we have tangible properties, we have lands, we have cars, some of us have houses. Those are properties we can touch and feel. But intellectual property, like the name implies, are intangible properties, creations of the mind that we cannot see or touch. But these are properties that can bring us wealth and change some of us lives around. And then there's something we used to say at WIPO that when you look at the financials of some of the top businesses and organizations in the world, organizations that are doing so well right now, you will realize that some of like 80% of their revenue are generated from their intellectual property and not even from the landed properties that they have. A good example would be like maybe organizations like the Apple, who have protected different aspects of their products and are getting a lot of revenue from that protection. So in simple words, IP are just creations of the mind. They are ideas like that have been expressed. They are inventions that have been taken further. They are like the music, the designs that people have come up with and taken further and protected. And there are different types of intellectual property. If I recall correctly, I was taught intellectual property in school. I am also a lawyer. I studied law at the University of Ilorin. And I remember intellectual property was one of the courses we were taught. So I want to believe maybe a lot of lawyers in the house may be able to relate to this. So there are different types of intellectual property. There's copyrights, there's trademarks, there's patents, and there is trade secrets, there is geographic indication, plant variety, industrial design. There are so many like that. I really wish my presentation could come up, but still not loading yet. But I'll start with copyright. because Michelle had already talked about copyright, so I'm just going to make it brief. Copyright, like in the simple terms, are just rights that are artistic rights, literary rights that are protected by IP, such as your music, your books, your comics, your coding. Even copyright is even protected. Softwares are also protected by copyright. And that's bringing me to the digital age, in the sense that if there are any music you are creating right now that is on any of the social media pages or any of the streaming platforms like YouTube, Spotify, all of this content that you have created are supposed to be protected by copyright. And YouTube, for instance, I am very sure they have very strict copyright policies that ensures that artists are being protected in the digital age. Because, like, it's very easy for anyone to come up with a content, and it's also very easy for anyone to steal your content currently. Sorry, Godwin, I just saw your message. So, like I said, my laptop is completely down. It has been restarting since I started. Even I cannot see my presentation, unfortunately. I would have sent it to Abiola. I think that's a mistake I made. So once I get my laptop back, I would definitely share with the organizers, and maybe they can share with everyone. So sorry about that.
Okay, sorry, ma'am. I was going to suggest, okay, you don't have access to it on your laptop yet, because I was going to suggest that you can just share it with me so that I'll share my screen from here.
That's what I'm saying. My laptop went down. I don't know why. It's rebooting now. Yeah.
Oh,
Which is why I said
no
it's so
problem.
funny, because when Michelle was presenting, it was perfectly fine already. And then but once it's
Okay, you can.
finished loading, I'll keep trying.
Okay,
Yeah.
ma'am. Thank you.
So to protect your ideas, to protect your content, you can use copyright. And a lot of streaming platforms, like I said, have strong policies that ensures that artists are protected. For instance, if you want to upload songs on some streaming platform, you have to be able to identify that this content belongs to you. And if it doesn't belong to you, whoever owns it can flag it down to say, this is my content, this is my digital ID, and this content belongs to me, and then YouTube takes it down. So in the digital age that we have, even though you have IP that can protect you, there are still a lot of challenges that can come and that you need to sort of protect yourself against. So that is copyright, but I won't go into the details because she had already done that. But I just want to also mention that copyright is also have two types of rights: the moral rights and the economic rights. So from your books that you have created, from any content you've created, you have the right to make money from it. And that is what a lot of people are doing right now. And also for all the other rights, which is the moral rights, for as long as you live, the copyright moral rights belongs to you. No one can take that from you. In some countries, copyright is protected for the lifetime of the author, and is some countries 50, some countries 70 years after death. And also, copyright can be licensed also. So you have the right to say, even though this copyright belongs to me, I would like to license this particular author to reproduce, to broadcast, to perform. So copyright is quite deep, but those are the different elements of copyright. And the next type of IP that I'm going to talk about is trademarks. And trademarks is one of the actually, trademarks is my own favorite type of copyright, because I think it's one of the best and easier way to make money in this digital age. What is trademark? Trademarks are just identifiers. How do I identify this product as mine? So I put a mark to it. For instance, trademark has been in existence as far back as 1800s with the Indians. When they are making their shoes, when they are making anything that comes from them, they put a slight mark to you to show that, okay, this belongs to me. So a good example of trademarks, Coca-Cola, how it is written on their bottle. I don't think anyone will go anywhere and not be able to identify that this is Coca-Cola and this is original Coca-Cola. There's also another good example I like to always make, which is the Apple sign at the back of all iPhone products or Apple products with the half-eaten apple. So for trademarks, you have to, once you put a mark to your product, it identifies you wherever you are. And for your trademarks to be accepted, it has to be distinct and it has to be descriptive. So your mark must be very distinctive to your product. For instance, you cannot be in a farmer producing maybe oranges, and then you say, okay, the name of my product will be oranges. But for Apple, which is a phone, you were able to come up with such a distinctive name, such a distinctive sign to identify their phones. Nobody would relate Apple to products. But one of the challenges that trademarks experience in digital age is because intellectual property are territorial, like Michelle had said, intellectual property are territorial. That is, if you register your trademark in Nigeria, it's only protected in Nigeria. But because of how global the world is now, because of how everywhere is connected, it's possible that you would be online one day and see like a trademark or a name or a logo that looks almost as similar to yours in another country, like maybe Ghana, like maybe Kenya. And because your IP is not protected in Kenya, then Kenya's whoever is using it has the right to continue to use that trademark. So that is one of the challenges I see that a lot of businesses are facing in the digital age. How do you distinguish your products globally? And this is where WIPO comes in by bringing in the Madrid system. So one of the solutions that we have at WIPO to resolve the challenges and disputes that may come up within the global age with respect to IP is to have international registration system. So at WIPO, we have something that we call the Madrid system. And the Madrid system is a system whereas all like member states to contracting parties to the Madrid system can protect their trademark in as many countries as possible. So for instance, if your trademark was registered in Nigeria, you can decide to protect your trademark in Nigeria, in the US, in the UK, in China, using the WIPO system. And that makes it easier and sort of solve some of the disputes we have ongoing on in the digital age with respect to trademark. But unfortunately, currently, Nigeria is not a member of the Madrid system, but Nigeria is in the process of being a part of the Madrid system. And once Nigeria is a part of that, a lot of the challenges that we experience in the digital age with respect to trademarking would also be resolved. And the next type of IP that I think talks a lot about focus a lot about the digital age is patents, which is like inventions, inventing something new, something unique, something that isn't obvious. So patents is like you can either use patent to protect a process or a product. For instance, one day there wasn't like a light bulb and someone woke up and said, well, when it gets dark at night, how can I make it brighter? How can I make the house bright and beautiful? And someone created the bulb. That is an invention that was patentable as far back as the 1800s. So with patents, with a lot of the frontier technologies that are coming up now, the blockchains, the cryptos, the metaverse, these are inventions, these are new technologies that we can and using the patent system. Sorry, because I'm using my phone, a lot of messages and calls are coming in and I'm really distracted. Really sorry about this. So I was saying that you can protect inventions through the patent system, and it is one of the best and greatest types of IP that I think ever exists, because I believe it is the process of patenting that has ensured that there are so many inventions in the world right now. So when you patent a product, for instance, there's a phone. Now phones have no buttons. It's all screen. Someone started that. When you patent a product, someone can come again to say, how can we develop the phone further? How can we make the phone be better? And then do something, create another invention to make the use of phone better. that kind of invention can be patented. So you can protect your inventions using patents. You can protect software that you're creating with patent as far as they are unique, they are new, and they are non-obvious. So if you come up with, and when they are non-obvious, if you're able to replicate them industrially, you can patent them. So another key type of IP that I think is also very important in the digital age for me is the industrial designs. And I think also after trademarks, the industrial designs are all like my second favorite type of IP. And the industrial design just speaks to the aesthetics of your products. For instance, the user interface in some phones are better than the other. The colors of some applications that people have developed are better than the other. So those kind of things can be protected by industrial designs. Likewise, industrial designs can also work with physical things. For instance, the slickiness of the Apple phone, the beauty of the Apple Watch. Those are things that are unique to Apple products and that can be protected with industrial designs. And in the course of inventing in the digital age, if you had invented like an application or you've invented like your trademarks or you've done something that is very unique, you can protect them with industrial design. Another good news is, like I said earlier, although trademarks are territorial, if you protect your industrial designs in Nigeria, it's only limited to Nigeria. But with the Lisbon Agreement treaty under the WIPO, you can protect your industrial design not just in Nigeria, but in countries across Nigeria. So that is how it works. There are so many other types of intellectual property that are also applicable in the digital age. There is the geographical indication. There are trade secrets. And I think trade secrets is maybe one of the coolest type of IP protection because like the names implies, you are just protecting your intellectual property without revealing it to people. So for instance, you have created, let's just assume that someone woke up today and creates some sort of artificial intelligence or some sort of AI that helps you to move from Nigeria to London without having to go through the airports, airplanes. That sounds more like jazz, but let's just assume that there's an invention like that. That is an invention in the digital age that is protected by intellectual property, right? But the person can decide to not let the world know how this invention came about. The person can decide to say, this technology that I have created, I'm not going to reveal to anyone on how it is done. That is also a type of intellectual property, even though this kind of thing may be beneficial to so many, but they can choose not to let the world know. And unlike patents, for trade secrets, you don't have to reveal, but unlike patents, you have to disclose some of your inventive steps, which is good because then people are able to replicate or advance on the steps that you have already created. Okay, I think my computer is back. I'm trying to come back in. And then I can find my presentation. I know my 30 minutes is also almost off. So to not just waste our time, these are the type of IP we have in Nigeria. This is sometimes how they relate to in the digital age and how we can apply them to our daily life. So I know there are some inventors in the house. There are some innovators in the house as well as lawyers. For the innovators in the house, I think my conclusion for you will be that for the inventions you are making, be aware that there are a lot of intellectual property that's in those inventions and they can be protected with maybe patents, with trademarks, with copyright, with industrial designs, and even with trade secrets. So if you're creating something innovative, if you're creating something that no one has done before, bear in mind that you can use IP. Sorry? Okay, bear in mind that you can use IP to protect them. And also for the lawyers in the house, I would say that if you have clients who has invented or okay, so if you have clients, okay, how do I do this? if you have clients,
I guess it's the service that.
So if you have clients who have, can you hear me now? Hello?
We
Okay,
can.
I think I'm using my phone. All right. So if you have clients who have like invented products, written a books, written a song, you should advise them that they should protect their invention with the different types of IP. And also, can you make me okay? Let me show my screen with the different types of IP. And also, you should advise them that they should make use of the WIPO system that allows for them to protect their invention worldwide and not just in Nigeria. Because, like I said, um, trade intellectual property are very territorial. Can you see my screen now?
Yes.
Yes, now
Yeah,
we
so
can.
sorry. I think I rushed through my presentation and I don't even know if I missed out anything. So I'm just going to go through it. Okay, so at WIPO globally and at WIPO Nigeria office, we have a lot of programs and innovations that we have put in place to help young people in the digital age to advance their work and to also help them to learn more about intellectual property. Like I said about at the beginning, us at WIPO, we are very, very passionate about raising awareness and building capacity on intellectual property. As many creatives and innovators are in the world, we are happy to let them train them on IP and to put as many programs as possible out there to help them to learn about IP. And one of the great things, innovations we have at WIPO is the TIC centers. So it's called the Technology and Innovation Support Centers. And globally, we have about 900 TIC centers, and we provide innovators in developing countries, Nigeria inclusive, with access to Nigeria inclusive with access to locally based quality technology information. In Nigeria, we have about 60 something innovation tech centers where we allow innovators to go there and have access to intellectual property knowledge and assistance that they need. We also have the Inventor Assistant Program. We also have the WIPO Academy, and please kindly make use of the system that we have at the WIPO Academy. Also, in the Nigeria office, we currently have some programs that we are running out for young people, for innovators, and we have one that is called the IP Labs. These IP Labs will designed this program to cater to innovators and startups in Nigeria. So if you know any early stage startups or founders that may benefit from protecting their innovation in the digital age, you can tell them to register to the IP Labs program. Applications are still on for that. Also, we have created a WIPO Green program, and that is mainly for green innovators in Nigeria. Like we know, it's important that we build inventions that support sustainability and green ecosystems. So this particular program would help startups, founders, innovators in the green space to learn about IP, to learn how to identify the IP components of their inventions and technologies in this digital age. And also we have a program that we call the IP Shalaye, and I know everyone here is a student, university student. IP Shalaye program is designed mainly for Youth Corp members in Nigeria, for coppers, like we usually call them. So I encourage you, if you have friends that are coppers and may be interested in being part of this program, kindly let them know. Applications will be opening soon. And I also encourage you yourself that when you're done with school and you want to be part of the IP Shalaye, please feel free to reach out to me or to anybody from the WIPO Nigeria office. We are happy to take you in and help you learn as much as about IP.
in the digital system. At the last IP Shalaye program, we had 28 corpers that had created innovations to solve problems in the digital age. They were able to develop about 5 solutions to farming, to agriculture, to housing and accommodation, to even career path for young people. So I encourage us to join this kind of program to help us boost our knowledge of IP. We also have other programs like the branding projects under the trademarks registry. And for that project, we are mainly teaching people how to identify the IP components in their businesses so that they can do better with their branding and compete on the global platform. We also have a project under the Copyright Commission called Indigenous Fashion and Crafts Industry Program. And that is also to help local indigenous businesses to identify the IP in their businesses. So please, I'm so sorry I took our time, and I will share my presentation with the organizers because I know I didn't really follow it as I would have loved to because I couldn't get access to it. But I'll share this with the organizers so everyone can have it. And if you have questions or comments, please feel free to ask and feel free to reach out to me via my email address. Thank you very much, everyone.
Okay, thank you, Ma. Thank you, Miss Famuyiwa. So, does anyone have any questions from the audience? She has spoken at length about intellectual property and how the Nigerian Office of WIPO is involved in intellectual property. So, if anyone has any question or clarification for Ms. Famuyiwa. Okay, Wendy Banda, you can speak.
Okay. Hello, madam. How are you?
I'm fine, thank you.
I have 2 questions.
Mhm.
The first one is related to artificial intelligence. Is WIPO Nigeria or just WIPO in general uh, planning to make any legislation or directive in relation to the use of artificial intelligence in respect to human rights and other international laws? That's the first question. And my second question comes to the issue of illegal downloads of music. So piracy is a big problem. Do you know any countries that have put measures in place to stop piracy in music or the illegal sharing of music? Thank you.
Okay, any other questions? Okay, so okay.
Okay, so I think I have a question. So I think I'll just ask. So my question is about I mean, we know we're in digital age. So my question is mainly about ownership, claiming ownership of content in, or like on social media in general in the digital age, because we understand that I think there are issues with like oh, this is my content, or I did this first, but there is no way to claim the ownership of stuff. And there are issues where someone posts probably some things and then does not know that, oh, this person has done it first. So I want to know if there are any laid down regulations or just processes about claiming ownership of content, and how like digital content creators can go about this. Thank you.
Okay. Any other question?
One more question from Huda.
Okay.
Yes, I also have a question. So first, I would thank Miss Salau for asking that question, because that's a question that I've had for a while. But I recall during your presentation, Ma, you spoke about, I think, IP green. So I just want to ask, what role does IP play in the agricultural sector?
Okay. Any other question? Okay, so I'll start with the windy bandy. Okay, so at the WIPO Nigeria office, like I said, we are an external office. We do not make laws or regulation. But currently at the WIPO HQ, there's something we call the AI and IP Frontier Technologies Division. So there has been a lot of discussions on how IP relates to artificial intelligence and how artificial intelligence is also affecting intellectual properties. Currently, there are no global rules from WIPO that regulates IP and AI, but these are talks that have been ongoing on how to develop policies, develop legal regulations around the interconnectedness of artificial intelligence and IP. And if you were present during Michelle's presentation, she talks a lot about the General Assemblies of WIPO. She talks a lot about the committees on copyright. So for similar things are applicable in this IP and Frontier Technologies Division. They have meetings regularly and they have discussions regularly where they are discussing the different types of AIs, the different types of frontier technologies, including AI, and how they are interrelated to IP and how to come up with policies for these ones. With respect to illegal piracy, like you said, this is one of the major problems of creatives in Nigeria. Like I don't know if Wendy is from Nigeria, but I am very sure that in Nigeria we have the Copyright Commission, the Nigerian Copyright Commission, and there's the Nigerian Copyright Act. The Nigerian Copyright Commission is in charge of is in charge of addressing every infringement of copyright infringements of which piracy is included. And the Act also provides how the Copyright Commission can protect creators from infringement. I do not know about other countries and their laws, but I'm sure that in Nigeria, we have the Copyright Commission and the Copyright Act that is working actively to curb piracy. And if I'm going to also advise creatives or people who are churning out content on how to protect their ideas and their content, I would say it is to monitor the content that you have. And sometimes it's difficult for creatives and creators to monitor. So that is why we have the collective management organization. They are called the CMOs. So maybe after this meeting, if you're really interested, you can just research on CMOs. CMOs help you with illegal piracy. They help you from your work from being copyrighted without your permission. So CMO is like if I want to bring it down to our level, CMO is like a student union or a trade union or the Nigerian Labour Congress, but for copyright issues. So if you have a movie, for instance, and you have produced the movie, it's out in the cinemas or out on YouTube or out just in the old digital space, you can you can pay to be a part of the CMOs. You pay to the CMOs. What the CMOs does is they continuously monitor the use of your content. And is your content be illegally pirated in Kenya, in Sokoto, in Kaduna? This is their own work. They continue to monitor for you, ensuring that nobody is illegally pirating your work and ensuring that you are getting the revenue that you deserve as a creator for your work. So aside the Nigerian Copyright Commission and the Copyright Act that we have in Nigeria, there's also the collective management organizations. And if you are not Nigerian, if Wendy is not Nigerian, CMOs are global. They are everywhere, not just in Nigeria. So I'm sure that there will be some CMOs in your country as well. For the content for digital content creators, like Abiola has said, to be honest, I also think this is one of the challenges of digital, what's it called? The digital age, challenges of content creators in this. How do you ensure that your content are not being stolen, cyber thefts? Because someone has gone on Instagram to create a content with, I notice when I go on Instagram these days, I see the same type of reels with different type of faces. And sometimes I wonder who started the content first, who did it first? I really do not know. But in this kind of situation, how do you protect your content? Because it's just out there in the open space, which is why I think that maybe I would advise that for content creators, one of the easiest places to probably put your content would be like organized streaming platforms like the YouTube, the Spotify, that you can use your digital ID to protect yourself, because there's something called digital ID. Every creator can pay to get a digital ID. And once you get a digital ID and you upload your content online with your digital ID, it's then very difficult for anyone to steal your content without your permission. And if you are part of the CMOs and you've identified that this content has been stolen, they can easily flag to YouTube or other streaming platforms to say, this video was first uploaded under this digital ID, and then it can be brought down. But for places like Instagram, TikTok, where it's really just an open place, it's still going to be very, very hard to regulate. And I'm sure that these are the kind of discussions that we would continue to have at WIPO and even at national level with the trademarks registries, the copyright commissions, the patent registries, on how we can protect digital content. And I think the last question from I think Oyerinde is the role of IP in agriculture, right? If I'm not mistaken. And I would say that IP plays a very critical role in agriculture. And this discussion is something that we probably even would need to create another webinar for entirely, to just talk about IP and agriculture. And first off, the technologies, I'm just even going to start from the very basic ones. The technologies, the tractors, the the different innovations that are making farming easier these days are all protected by IP one way or the other. They're either protected by patents because it's an invention. And then there's also a type of IP called the plant variety protection. And under the plant variety protection, this is a type of IP, by the way. Under the plant variety protection, farmers and breeders have the right to protect their agricultural invention, with plant variety protection. So what the plant variety protection does mainly is to say that if a farmer or a breeder comes up with a new type of seed or plant, let's say for instance, someone woke up today and is able to breed rice and beans together to form bee rice or to form a different type of crop, that kind of innovation is protected by IP. So that is a type of IP. And in Nigeria, for if the press, okay, Yerinde must be Nigeria. In Nigeria, we have the Plant Variety Protection Office and we have the Plant Variety Protection Act. So it says that even in Nigeria, farmers, breeders are protected by IP. There's also IP and food security. So IP is very closely related to agriculture, and there's also the geographical indication, which are protected by industrial products and agricultural products. And if geographical indication is also a type of IP, and what geographical indication just means is that for the agricultural aspect of it, it means that this plant or this fruit or this kind of food comes from this country or comes from this state. A good example that I may want to give us that we may be able to relate to is Ijebu Gari. I don't know if all of us on the line would know about Ijebu Gari. Ijebu Gari is from Ijebu. It's very peculiar to them. You may not find any other gari that is as sour or that tastes like Ijebu Gari. Ogbomoso mango. Ogbomoso mango is very peculiar to Ogbomoso. Like I remember when I came to Abuja, I was like, I went to buy mango and I thought every mango should taste like Ogbomoso mango, but it did not because Ogbomoso mango only grows in Ogbomoso. So for geographical indication, it's just saying that any food or any plant or seed that is growing or that tastes this a particular way because of the soil or because of the climate of a particular state, that kind of food or seed or food can also be protected by IP, and that can be protected under the geographical indication. But currently in Nigeria, we do not have a Geographical Indication Act or an organization that protects geographical indication. But these are things that other like developed countries are using. A good example would be champagne. Champagne is popular to the Champagne town in France, and champagne can only be made from champagne in France. And everyone, I'm sure, has tasted champagne at some point or had heard about it at different points. So that's just in summary how IP also relates to agriculture a lot. And I think the organizers can decide to do another webinar on the role of IP to agriculture or to food security. Thank you.
Thank you very much, Ma. That was very detailed. So I don't know if anyone has any other question, so we can round up the session. Are there any other questions? Okay, no one is raising their hand, so I'll assume we don't have any questions. Thank you, Miss Famuyiwa, for taking time out to educate us. I'm sure many people already have a better knowledge of what IP rights entail in Nigeria. Thank you, Ma. So I'll be calling on Karen now, Karen Elo, to close this webinar. Karen, are you there?
Yes, I'm here. I'm here. Thank you very much to our speakers. We had a very enlightening session. Very big thanks to both our speakers, Ms. Mitchell Woods and Ms. Olaronke Funiyiwa, for affording us the time out of their busy schedules to enlighten us on the proposed topic. It has been a very wonderful session, and I'm sure we've all learned a lot. And also a very big thanks to all of us who made time out of our busy schedules to attend this meeting, those of us present here on Zoom, as well as those joining us via other social media platforms such as YouTube. Thank you very much. AfriVatech will be hosting other such webinars and programs as we go forward, and we hope that all of us can be a part of those as well. Have a wonderful rest of the day, and thank you once again for joining in.
Thank you, Karen. Thank you, everyone, for joining in. Adewale, do you have anything to say or add? Okay, all right. So I think we can all leave now.
Everyone, I sincerely
Adewale, you
can you hear me?
Yes.
Hello? Okay.
Yes.
So thank you so much, everyone. Especially, I want to appreciate our guest speaker. I know that you really disturbed Miss Wood very well. And thank you so much. I know I've been communicating closely with Miss Oroke. Thank you so much for we're glad to have you here. And also, I want to thank the law students. So we partner with them for this one and also the technical students.
Sorry, I can't hear you.
Yes, Adewale, we can't hear you anymore.
All right, I'm done.
All right.
I'm
Thank
done.
you. Thank you. Thank you, everyone, for
So
joining.
what we have is that the slide presentation slide. Okay, what will happen is that the presentation slide we are going to send it to the group. You can take your time to go through it, and if you have any question, feel free to drop it with any of the admin.
Okay. So can we go?
Yes, thank you, Ma, for joining in.
All right. All right. Thank you, everyone. Bye.
Bye, Ma. Bye. Bye, everyone. Thanks for taking
Thank
time out.
you. Bye.
Bye. Can all leave the call now?